Well, good morning, everyone on Central Standard Time. Good afternoon to those that are on the East Coast. This is our second public meeting under the O'Donnell Consent Decree. The last one we had was in October of last year. It was a little over a year ago when Judge Rosenthal accepted the joint motion to appoint the independent monitors. And since then, we've been meeting with the monitors on a regular basis, along with the other parties. And we recognize that the input and involvement of the residents of Harris County are absolutely essential to long-lasting reform, and hence this meeting, and in part why the Justice Administration Department was created. And one of the items that our department was tasked with was the implementation of the O'Donnell Consent Decree. And I can say that of the various assignments that we've got, this has been some of the most rewarding work that my team has gotten to undertake. Next slide. Today's agenda, I'm providing some opening remarks, and I'm the director of the Justice Administration Department. I'm also currently serving as the interim director of pretrial services. The purpose of today's meeting is to get the 12-month report from the federal court monitor, Brandon Garrett, and we will also hear from the federal community work group that is headed by Professor Sandy Thompson. We'll have a report from the county attorney's office. I think Rachel Frazier will be giving that. We'll also be getting a report from the sheriff's office and the county criminal courts at law. The sheriff's office will be a little bit thin on the call, and I think we will have a representative, but there is a funeral going on for one of its deputies that was lost to COVID. Bree has sent me a note regarding questions. Throughout the meeting, questions can be asked utilizing the chat feature. JAD staff will be monitoring the chat, and during the Q&A portion, questions will be presented to the panelists. Next slide. So with that, I will go ahead and turn it over to Professor Garrett to provide an update of the first 12 months now.
Thank you so much, Jim. It's wonderful to see you all. We, on our team, Sandy Thompson at University of Houston Law School, myself at Duke Law School, Dottie Carmichael and her colleagues at Texas A&M, at PPRI, and in general, our monitor team are honored to be doing this work. It has not been an uneventful year. It has been certainly full of challenges, and we've been so impressed with the work that the county has done to rise to those challenges and ensure on its end the full implementation of the O'Donnell Consent Decree. We just a month or so ago released our year-end report describing our findings, and the report that talks not just about analysis and data and trends, but also about the important milestones and accomplishments in terms of implementation. If you could switch to the next slide and switch slides again. We do have a website where all of our documents are available, including our reports. These are just our beautiful faces. Let's switch slides one more time. What we want to highlight is just how dramatic a shift has occurred under the consent decree. As you all know, the consent decree is limited to misdemeanor bail reform. And in some ways, things have dramatically changed, and in some ways, things have not. There are certainly still the same bail options available as before for cases, carve-out cases that raise public safety concerns. But many more cases in these low-level misdemeanor matters that don't raise such concerns are eligible for a general order bond at the point of booking. One feature, though, of the O'Donnell Consent Decree, which we really underscore and which often gets sort of neglected in the public observation of what has happened, is that because of this focus on the carve out and more serious misdemeanors that do have a bail hearing where the full options are available, those hearings can be far more robust than they were in the past. The defense attorneys are now appointed at all those hearings from the public defender's office, unless someone has their own private counsel. And there is a rigorous constitutional standard that hearing officers and judges must follow when deciding whether someone should be released with appropriate conditions or detained. Let's turn to the next slide. In terms of major accomplishments during the year that this consent decree has been monitored by our team, well, one was our last public meeting, and of course we're having the second one right now. The first trainings have occurred, and a second round of training will be conducted shortly concerning all the detailed requirements of this consent decree. It is a lengthy and detailed document. We described in our report how early on the hearing officers had only about a line of text to explain why they had clear and convincing evidence to detain someone or no other conditions could suffice. That wasn't enough room for them to provide a factual findings and a record for their decision making. And the criminal court judges have developed and approved a set of redesigned top to bottom misdemeanor pretrial hearing forms, which far better reflect the flow of information and the requirements of the consent decree. It's far easier to understand the reasoning and the factual support for a decision to release or detain someone at a 1517 misdemeanor hearing. We think that's a really important improvement. And another important accomplishment, I'm not sure there's anywhere else in the country where defense lawyers are provided with electronic discovery before a bail hearing. There are not that many hours for that to happen, and it was a really impressive piece of implementation that took a lot of hard work, particularly by the folks at JAD, to assemble this new electronic system with cooperation from the district attorney's office. They have a new e-charge platform, which makes it even more consolidated and convenient to assemble this information before pretrial hearings so that everyone has access to the record that the hearing officer and the judge will then use to decide what the appropriate pretrial outcome is. And a lot of hard work was also done by the courts to implement the new court appearance policy so that data is now recorded, so that it's clear to everyone appearing in misdemeanor cases what their options are, when it is required that they be there, when they can reschedule a court date. And that work has been really, really important as well. There's other work to come, including an evaluation of the indigent defense systems involved in misdemeanor cases. If we could switch slides now and start saying a little bit about our findings in the short amount of time we have left. There's a lot of focus on repeat offending, and public safety is obviously deeply important. What we find is that the implementation of Rule 9, which was adopted by the judges before the consent decree was finalized in early 2019, that brought with it the rule that for all but these carve-out offenses, misdemeanor arrestees were to be processed but then released on a general order bond at booking. So many more people have been released as a result of that Rule 9 change. We do not see, though, any meaningful change in repeat offending. We, in fact, see a gradual decline in repeat offending rates across a number of measures. There are a lot of different ways one can look at repeat offending. The main measure that we report in our monitor report is a really, really broad measure, where if someone commits a misdemeanor at one period of time, then another, that would be counted as separate incidences. Or if they commit several misdemeanors on the same day, that would be triple counted. If you just look at the number of people that come back, say over the course of the year, the reoffending rates are lower, but again, they have declined. The only slight increase we saw was the share of misdemeanor cases associated with the new felony, a very small increase from 10.7 to 11.4%. So, not much more than 0.5%. We were also interested in this question, are there frequent flyers? Has that changed with the new approach? And it has not. And of course, if a person is out on misdemeanor bond and commits a new offense, they're no longer eligible to get another general order bond. That's one of the carve-out categories. We've also seen a steady reduction in the number of misdemeanor filings each year, and we're still looking into what are the different reasons why that has occurred. One piece of it may be the district attorney's office's diversion programs that have been implemented over the last few years. We also talk about how, like you would expect under these reforms, the average duration of pretrial detention has decreased markedly. We have not seen any change in the sex, gender, racial distribution of misdemeanor defendants. We have seen an increasing share of Latinx misdemeanor defendants over time, although a share that corresponds with the Harris County population. Go to the next slide. We do describe, though, although we don't see a trend towards more repeat offending, we have seen a trend towards more new cases of domestic violence misdemeanors, and that's of public safety concern. We also note, and this is something that we plan to explore in our future work, we're trying to explore it better now, in terms of the people who do come back repeatedly, people who are flagged as having severe mental health needs, and people who are flagged as having an address at a homeless shelter are twice as likely to be rearrested. And so we want to look at more carefully why is it that people who are flagged as members of those vulnerable populations are so much more likely to come back into the system. We also want to look at this small subset of cases where people spend quite a bit of time in the jail in misdemeanor cases. These people who are in the jail for the longest amount of time also disproportionately include people with mental illness or homelessness, and we want to better understand what's going on in those cases. We also note, just in terms of the financial savings of the public in Harris County, far fewer people have secured money bond in misdemeanor cases. It's 14% of misdemeanor cases last year, down from 92%. Like, almost all the cases had secured money bond back in 2015. This is enormous in terms of the cost savings, it's people paid over $4 million in 2016 in terms of the fees they paid to bond companies in misdemeanor cases, and that was down by over $3 million in 2020. And so that is, an enormous financial benefit to the Harris County community. Next slide. Andy, would you like to jump in and introduce our community working group that's been guiding us throughout this year? I don't know if both of us can talk at once. Sandy,
Yes, just a second. We're going to get her added on the line.
Okay. We didn't realize took some logistics to add people.
Okay, I think
Hi,
I'm
Sandy.
on. Hi. Yes, I've had the pleasure of working as deputy monitor for the last year. It's been a real honor, and my role has been to oversee the community working group, and you see their names and faces here. And these individuals are leaders in our community who represent immigrants, women who work in the sex trade, homeless people, people with mental illness, law enforcement, the downtown business community, veterans, people with experience in the criminal justice system, having spent time in Harris County Jail, and civil rights advocates. And they have assisted us meeting regularly with us, with the monitor team and with Harris County officials to stay informed about what's going on, to help us push out the message about the work that's being done, but also more importantly, I think, to get input from them. And so we have use their guidance in the electronic discovery process that Brandon was talking about, and how to collect data from law enforcement and communicate effectively with law enforcement. They talked about the importance of collecting data on ethnicity, and so we've done work on that. They've guided us in helping to design training materials and just giving guidance to the organization doing that work. as well as I think really critically is organizing meetings with advocates from around the entire Harris County area who do work in mental health, domestic violence, work with women and immigrants, and the homeless. So it's been a very important um, contribution that the group has made, and we look forward to continuing that work. It both enriches the work that the Monitor team is doing, but even more importantly, I think it helps Harris County and the different agencies of the Justice Administration Department that are involved in the implementation of this consent decree.
Great. And maybe we should stop there. We have a number of slides illustrating different data from our findings, but we've talked about all that data, and we could pull them up if folks have questions about particular findings and observations. But hopefully that gives you a good overview of our work with community stakeholders, our data analyses, and all of the implementation that the courts and the county have been working hard on during this entire year. We should note that there's still some important implementation steps yet to come. The main data that we haven't told you anything about is data on what happens when these cases proceed to a disposition. How long does it take for misdemeanor cases to be resolved? We certainly know that COVID affected dispositions this past year. How many of the cases plead out, under what sentences? There have been work done in the past suggesting that cash bail put pressure on people to plead guilty, and people who are detained in the jail ended up having more serious sentences than those who were not detained in the jail. But those are all questions that we hope to look at next as we incorporate data on dispositions. We would really welcome your input on any aspects of these misdemeanor reforms that you have questions about, or you think that there could be useful lessons drawn in terms of our analyses. It's not all big data. We talk in the report about how we've been watching hearing videos, we've been watching live streams of misdemeanor court, and reading opinions by judges and hearing officers to get a better sense of just what's happening day to day in the misdemeanor bail dockets and in the misdemeanor dockets. Again, like Sandy and I and our whole team are honored and privileged to be serving in this role to inform the federal court in this really important consent decree. All eyes are on Harris County. This is the first federal consent decree of its kind, and sets out an important model for how to really rethink and improve a bail system. And so we're really proud of what everyone has done to accomplish so many reforms in a fairly short amount of time, and we're excited to see what comes of the implementation work that remains. Thank you all so much.
Thank you so much, Brandon and Sandy. We appreciate you and your leadership roles through this consent decree. We are seeing your questions in the question and answer section. We are not ignoring you. We're going to wait to the end and answer all of those questions at once. So keep them coming and we will get to them. Next up, we have Rachel Frazier from the Harris County Attorney's Office.
Thank you. Good morning. My name is Rachel Frazier, and I'm an assistant Harris County attorney. Next slide, please. The county attorney's office has played an integral part in assisting with the implementation of the O'Donnell Consent Decree. We continue working with stakeholders to ensure there is a constitutional and transparent pretrial release and detention system to safeguard arrestee equal protection and substantive due process rights, and to ensure public safety, access to information, and systemic transparency. Next slide, please. The county attorney's office collaborates with the Harris County Purchasing Department for all requests for proposals, including holistic defense evaluation, Harris County compliance training, updating the court notification system, and in the mitigation of court non-appearance studies. Next slide, please. In addition, the County Attorney's Office provides legal consultation and advice regarding the implementation of discovery before 1517 hearings, updates to the court's notification system, database updates, and dissemination of information to stakeholders relating to unsecured general order bonds. Next slide, please. The Harris County Attorney's Office meets regularly with the monitors and working group and continues representing Harris County in working towards the effective and enduring policy implementations of the O'Donnell Consent Decree with the goal towards improving justice. Thank you.
Thank you so much, Rachel. We appreciate you so much for taking time to explain Harris County's county attorney's role in this process. Next up, we have Victoria Jimenez, who's representing our sheriff, Mr. Gonzalez. Take it away, Victoria.
Good afternoon. My name is Victoria Jimenez, and I'm the Director of the Legal Services for the Harris County Sheriff's Office. As Director, I not only lead a team of approximately 15 paralegals that provide various information to the public and other departments. I also advise all of the other departments within the Sheriff's Office on any of their legal matters, as well as help implement changes to the office as a result of justice reform, police reform, and bail reform. As far as bail reform is concerned, I meet regularly with the monitor team and have provided legal consultation to the Sheriff's Office since the conception of the consent decree. Recently, the Sheriff's Office has been working with vendors to update several forms involved in the bonding process. We also work closely with the Justice Administration Department on various initiatives to continue to provide a high level of public service while promoting public safety to further the mission of the Sheriff's Office led by Sheriff Ed Gonzalez. Bree, back to you.
Thank you so much, Ms. Jimenez. We appreciate it. Our next presenter will be Judge Walker from our county criminal courts at law. Thank you, Judge Walker.
Thank you, Bree. Again, thank you for allowing us to be here today. My name is Judge Cedric T. Walker II. I'm the presiding judge of Harris County Criminal Court at Law Number 11, and also currently serving as the presiding judge of the Harris County Criminal Courts at Law, the 16 misdemeanor courts we have in Harris County. I wanted to give you all a little update on some of the things that the county court judges have been doing since the last public meeting on O'Donnell. So since that time, we've worked with a group called Ideas 42 on developing some content for some updated and revised court appearance forms, including not only the case reset form that's used certainly on a day-to-day basis for the folks that appear in our courts, but also revising the general order bond, the cash bond, the personal bond, surety bond forms that are currently in use to try to make those documents easier to comprehend and understand for those folks who are being asked to appear on the particular court dates that they have. And with their consultation from Ideas 42, we're working on content just to make sure that people have a full picture of what they're required to do, and also give them some guidance on some things they may need to research in terms of questions they may have, provide them some websites or other information that will help them get the answers to those questions, and also, of course, lead them to their attorneys if they have those as well. We've also been working on finalizing an online case reset form option where a attorney or defendant in a particular case can potentially go online and request a reset and have that email sent directly to the court coordinator to try to potentially facilitate a reset online. That form is still in the process of being worked out. And we also have to work on some language for, making sure people understand that the request itself doesn't automatically mean the court is going to grant the reset, but that the judge and the court staff will have to obviously look at each case on an individual basis to make that determination where the reset can be done without an appearance, so to speak. And we've also continued to implement the consent decree policies, specifically in terms of the daily bail review hearings that we may have for someone who is not granted a personal bond at probable cause court. And we have to see them on the next business day setting to essentially give them a hearing that is substantially the same in terms of procedures as the hearing they would have had at probable cause court. So that's what we've been doing at the County Criminal Court at Law Division, and I thank you for your time and your consideration.
Thanks so much, Judge Walker. We appreciate your leadership in this process and working with all of our vendors to get all of the implementation in. And so because all of you have joined this meeting today, luckily now you are a part of JAD's newsletter. So all of the updates that are being made countywide, you will be able to share with, and you'll be able to share with your constituents. So the first question that was asked today is, may I have a copy of the slides? Of course you can. So this will be posted within 48 hours to JAD's website under the O'Donnell Consent Decree. So you will be able to review them independently and share them. If you have any additional questions, you can continue to email us at JAD and we can ask them or get you into the right people. The next question was, what is the Latinx term, and does that have special meaning in an academic legal community? Professor Thompson, would you like to answer that for us? Sorry, we're working through technical difficulties. We'll get her online.
Okay, so the term Latinx is one that has been adopted of late to encompass a broader range of individuals who, previously we might have referred to as Hispanic, Mexican American, or what have you. There have been many such labels over the years, but the term Latinx is essentially individuals of Latin American descent, and the X is to make the word not gendered, so it's not a Latina or Latino, but it includes all individuals. At least that's my understanding of it, and so we use that term in the Monitor report because it is currently considered the most appropriate way to describe that community. But we realize that there's some controversy and some individuals who would prefer not to have the change. Even among my colleagues at the University of Houston, there's been some pushback, but our students recently changed their name from the Hispanic Law Students to the Latinx Law Students Association. And so again, I think it's just a term that will be seen more in the future.
Thank you so much for that explanation. The next question that we have is, could the reduction of case file might be due to the fact that the officers do not bother arresting offenders because they know they will get released? So any of those presenters can answer that question. I'll ask it one more time. Could the reduction of case file be due to the fact?
Oh, sorry. I was trying to answer, but I was muted. Yeah, so that's a great question, and we noted that we've seen a decline in the number of misdemeanor bookings each year. The decline has been steady for a couple of years now, and we can't answer the question. We don't know all the reasons why. The decline began before Rule 9 was adopted. And so we started seeing some decline beginning in 2017. So it may be that there are a few different reasons that explain the decline. Some of it may be the new diversion programs that the DA's offices have adopted. Some of it may very well be, like the question suggests, that law enforcement see less of a need to arrest in certain circumstances. Changing priorities last year during the COVID pandemic may also have reflected informal or formal misdemeanor arrest policies. There also may be a decline in the incidence of some types of misdemeanors that may explain some part of it. It's probably a combination of all those explanations. To tease it apart, we would need more data from law enforcement. We did have a preliminary conversation and would be very interested in looking at HPD data to get us a better grip on that question, because I think it is a noteworthy trend and something that would be helpful for all of us to understand better.
Thank you so much, Professor Garrett. We don't have any other questions in the chat. So there's a question that came up that says, I have a strange question. Who is O'Brien?
Maybe they meant O'Donnell.
Oh, maybe that's it. So yeah, so Miranda O'Donnell is the person that the consent decree is named after. She is the one who began the class action lawsuit again with others. And so we call it O'Donnell because that is the person who initially filed the claim.
Yeah, if you read the complaint that was filed, it's on JAD's website, it's on ours. They describe the story of her arrest and the consequences it had. She was detained because she couldn't afford bail. She was separated from her child who she was caring for. It's a really her story was certainly one that affected me powerfully when I read the description of what happened to her when she was arrested in a low-level misdemeanor case some years back. And hers was one of many stories. In a class action, obviously, the case is brought by several people potentially, but representing a whole group of people. But you can read a longer version of her story if you look at that complaint document.
And the next question says, in your calculation of recidivism rate, did you exclude any cases such as people not on bond?
So if Brandon had his hand raised, I think he has to be prompted to.
There we go. Okay. Yeah, I don't have the power to unmute myself. So no, we did break down repeat offending in a number of different ways, but we did not exclude people in that way. We included people who, during whatever the time period was, 90 days, 180 days, a year after a misdemeanor booking, were charged with some other offense, whether it was a misdemeanor or a felony, and whether they were out on some form of bond or not. We also looked at just how many repeat cases there were, and so that's an even broader definition, which is in much higher numbers, because a single person could be responsible for a lot of cases.
Thank you. And we have another question in regards to bond. Can you talk a little bit about bond failure rates?
Sure. We describe some data on bond failure rates in our report. We note that bond failure reporting had been far from perfect during the time period in question, and so we know that we don't have perfect information, and that there was real discretion in the past where judges may have had their different sort of personal approaches towards when to fail bond versus not. And so taking all that into account, we still reported what we are able to see in terms of the share of cases resulting in bond failures. So one of the graphics that we had in our report described the share of bond failures within a year. And what we show is that in general, bond failure rates have stayed fairly steady. There has been there are certainly more people out on a general order bond, and more opportunity for a bond failure to occur because cases last longer. We saw a rise in bond failure rates in 2017 and 2018 in general order bond and personal bond cases, and then we saw a decline again in 2019. So, we'll see what the data looks like in 2020, and going forward, the rules have changed, and there are much clearer rules in terms of when one can reschedule one's court date versus when a judge finds that this was required that you appear and I'm going to fail the bond. And so it won't be particularly comparable because in the past there was a lot of discretion. Now there is discretion, but there's clear guidance in the court appearance policy. And so, it's too soon to tell what the data looks like under the new policy, since data has only been recorded under that policy for a short amount of time. But it'll be interesting and important to observe what happens under the new policy.
Thank you. And someone asked if we had published the website information. We did not. It is jad.harriscountytx.gov. And the final slide will have all of the information to the JAD website, to our Facebook page, to Twitter, and also to the Monitor's website. So that will be listed at the very end. We do have some more questions. The next question is, are you tracking citizenship status compared to the time of detention? I'll ask that one more time. Sorry, it was a little jumbled. Are you tracking citizenship status in relation to time in detention?
No, I just couldn't unmute myself. It seems, I think that maybe there's a lag and it takes a little while for the unmute button to show up. But no, we don't have that information. And in fact, that when we reported information about ethnicity, that is typically not collected. It's not required that that information be collected. So we described how we use the person's name and address to impute ethnicity. And there's some well-accepted methods for doing it. And so that provides a good estimate. But there is, quite a bit of missing information. People aren't asked to self-report their ethnicity, or if they are, it's sort of not required that that information be entered. But we don't have citizenship information. We do see when there is an immigration hold, and that's the reason why the person is detained. So that is something that we do see in the data that we get.
The next question is, since there are more people in general order bonds, even if the bond failure rate is the same, doesn't that mean that there are a lot more people failing?
Well, it's actually, so the share of bond failures is largely the same, and there are fewer people being arrested on misdemeanors. So there's also just a smaller misdemeanor population in Harris County. We're not entirely sure. We were talking earlier what all the reasons are for the decline in the misdemeanor population. But in general, it is a smaller number of people that we're talking about. It is also a carve-out offense. If someone commits a new offense while they're out on a general order bond, then they're no longer entitled to a general order bond again. So they could then potentially be detained, depending on what the hearing officer and the judge decide.
All right, we don't have any more questions in the queue right now. I just wanted to take the time to thank all of our presenters today. Jim Becky, which is our fearless leader. He's the director of the Harris County Justice Administration. And he is also the interim director of pretrial services. So he's been doing dual duty for some time now. So thank you, Jim. We would also like to thank Brandon and Sandy, who are our monitors and deputy monitors, Rachel Frazier, our assistant county attorney, Victoria Jimenez, director of legal services of the Harris County Sheriff's Office, and Judge Cedric T. Walker II, the Harris County Criminal Courts at Law presiding judge. And again, here's our website, and we'll keep this up for a little bit for the Justice Administration Department, our Facebook page, our Twitter page, and then also our monitors page. If you have any additional questions or concerns, please feel free to reach out to us at events@jad.hctx.next. These meetings will happen semi-annually, so look forward to another invite in October, but we're always in constant communication. So if you have any questions or things that you would like to add at any point, please feel free to reach out to any one of us. We would like to thank you so much for your time today. Thank you for your participation, and it was a pleasure to meet with all of you.
Thank you.